right, I recommit page 8. Get down to where it says Senator Gale explained that, yeah, delete 2. All right. And then in the review of the matrix, clause by clause, first schedule, that's page 9.
That was a beginning. That's the beginning. So that would be page...
Yeah, page 9. Yes?
Page 9 is what? Oh,
Yeah, page 9.
Yeah.
Second sentence, she read it was rejected
Yeah.
for one of the members to be a licensed teacher.
Yeah.
So the chairman read the recommendation for the owners of denomination of 4 members on the board.
So based on the
Was it rejected? She read it was rejected for one of the members to be a licensed teacher. Okay, maybe that's what they said.
yeah, it would have been from the recommendation.
Okay. All right. All right. Page 11. This is page 11. Page 10. Page 11. Page 12. Page 13. Hold on. Page. Page 13, then page 14. At this time, I see confirmation of the minutes of the meeting held on Thursday, February 2nd.
So move.
Okay.
So move.
Okay. So moved by Member Brown, seconded by Member Cuthbert. Matters arising from the minutes. There are a few matters.
Minister, before you get to matter, I will have to jump off at about 2:30 for an emergency matter, and I'll try to come back on if I can complete that matter before. So my apology if I leave before we complete this.
I'm sorry, do you have a matter arising? Member Brown?
No, I don't.
All right, great. So there's a matter arising with regards to ex officio members, and I recall that Dr. Gordon was going to speak to the SG. That's one matter. There's also a matter with regards to the tribunal. If you look at page, which one? The 5th schedule, where we were talking about the process. And it said that I noted the concern suggested the tribunals were pop-up, meaning ad hoc tribunals, which stated that they were not on the basis they were appointed for a period of time. She stated the concern would be deferred to the next meeting, something to do with the tribunal. Do you recall that? There are a couple of deferrals. One, I wanted the inclusion of a representative from the National Parent Teachers Association on the tribunal. Senator Brown asked for a deferment of the proposal. So those are the 2 matters, 3 matters arising. Ex officio and 2 matters with the tribunal. So Dr. Gordon, was there any further comment in terms of the CEO being ex officio?
Thank you, Chair. Good afternoon, everyone. Good afternoon, Minister. Mrs. Gordon-Jones actually found the communication that we got from the Ministry of Finance referring to the ex officio on the board. And in that communication, I think I'd better ask Mrs. Gordon-Jones to explain what was written.
Good afternoon, everyone. So based on the research, we noted the communication from the Ministry of Finance, and that communication alluded to Principle 7 in the corporate governance framework for public bodies, which was revised in October 2012. And the Principle 7 speaks to the role and authority of ex officio members. And the principle is there should be a formal and documented procedure for the treatment of ex officio members. This should be established in a code of conduct for boards of public bodies. It's the recommended practices included that ex officio officers should have the same duties, responsibilities, rights, and privileges as do all appointed board members, including the right to vote. The ex officio officer should not be expected to commit the government in respect of matters which are required to be referred to a higher level of authority. It further said that the ex officio officer should not endorse any action of the board which will conflict with the legal and ethical obligations of a public officer and the position he or she holds, and should advise against and vote against such action or ensure that the opposition is clearly recorded if no formal vote is taken. So basically the corporate governance framework for public bodies is saying that an ex officio member should be allowed to vote.
Ms. Gordon-Jones, is that you referenced that this was revised in October 2012?
That's the last update.
Since then, there has been updates, changes, laws with regards to boards of public bodies. How would you reference those relative to October 2012?
Well, the communication, Chair, that came from the Ministry of Finance, it was recent, and it alluded to that principle.
Just for clarity, that was the 2012 update?
Of the corporate governance framework.
And just for what's a particular clause in it that speaks to that? Just for my notation.
It's principle 7.
Principle 7. Thanks.
My understanding, Chairman, that there's been no change since 2012, and that represents the current position of the government of Jamaica.
Yes, Chair. The communication from the Ministry of Finance, it was actually in November of 2021, and it was in relation to the comments on the bill, and that's where it brought us to Principle 7 of the Corporate Governance Framework, which it says in its correspondence, which outlines inter alia that ex officio members should have the right to vote. And then it was the recommendation that the ex officio members be given the right to vote as stated in the corporate governance framework.
Should we therefore propose that the ex officio member be a member of the board in accordance with the corporate governance principles outlined by the Ministry of Finance, and either we write those words in or we write the details in. But it's accorded with my position last meeting that they should be able to vote, and I'd have no objection to that. So it is in accordance with government policy. I support it. How do we incorporate it if we need to in the legislation? Maybe the issue we have to resolve. But it has my support.
Members? All right, so that, if that is the latest in terms, Dr. Gordon? All right, so according to Principle 7 of the governance framework for public bodies, ex officio members should have the same rights on the board. All in favor, members?
Aye.
All right.
Aye.
It is carried.
Aye.
Okay.
Aye.
Thank you.
Lambert, you sound like you voted more than once.
Aye.
Well, that's not a bad thing when I have multiple votes.
All right, then we have two other matters arising from the minutes. The other one has to do with having the representative from the National Parent Teachers Association on the tribunal. The minutes noted that Senator Brown asked for deferment of this proposal. So Senator Brown, you asked for a deferment. May we hear from you?
Yes, I stand with the proposed composition minus the PTA rep. So it's lawyer, judge, ex-judge, lawyer, JTA. Thank you very much.
Members? No, I was the one who highlighted this. The cases I have read, they all involve students. Some issue between student and teacher. It's not just the professional conduct, Dr. Gordon, as you noted. Inevitably, that professional conduct has something to do with students. I'm not saying 100% of the time, but I would say 80% of the time.
Minister, please repeat your statement.
All right, so I was the one who indicated that I would like to see a representative from the National Parent Teachers Association on the tribunal, because the matters that I've seen so far in my tenure, they involve students.
In respect of the tribunal, Minister, please recall that by the time a case gets to the tribunal, it will have been through another process. It will have been through the committee of the board. It would have been through the professional, the PBCJ, by the time it gets to the tribunal. So at that point, it becomes a matter for the lawyer, the JTA, and the judge.
On the PPCC? Is there a parent represented on the PPCC?
whilst we do that, I'm just looking at the principal construct of a tribunal that suggests, in the first instance, an odd number. In the first instance. And most tribunals go by the construct of 3. Now, Minister, what you would be proposing would create an even number. I'm coming to that, coming to that. Constructs of this nature also, looking at the proposed composition, has the chairman, who is a retired judge, normally coming with the expertise of this nature, a retired teacher, and a representative of the Professional Teaching Association nominated by the association, who so happen to be a registered teacher. So I can understand that construct, given the scheme of things. Now, if you add the parent to it now, that makes it an even proportion in terms of numbering, then what would be that other discipline that we would be seeking to make it that odd number? Again, for purposes of deliberations, coverage, and also in the event of a dispute between the parties involved. And when I say the parties involved, now I'm speaking entirely around the composition. What would that other construct be? Because we have to take that into consideration. My preference, however, at all times, is to limit the numbering of a tribunal to the 3. That's my preference. However, I'm just putting it out there for consideration.
So in this case, member, we have the chairman, who shall be a retired judge of a Superior Court of Record. We have a retired teacher and a representative of Professional Teachers Association. So there's an overweighting in terms of teachers on this tribunal. Right? There's no offsetting. Where are the students represented? Where are parents represented?
It has a lawyer. Madam Minister, Chair. The original tribunal that we had in 2008 had a retired teacher, the chairman, and the JTA. The retired teacher was chair, and so there was a lawyer, a representative of JTA, and the retired teacher was a chair, was a retired senior educator. Now, in time, that was changed because of the backup of cases. Then the experience was that the cases weren't going very fast. And so that was changed, and now we have the judge, retired judge, the representative of JTA, and a lawyer, an attorney at law, and the cases have moved. We are on target. So the situation that exists now is a situation that has demonstrated to be more effective in ensuring that these cases are treated timely and fairly.
But there's a difference between, so the composition of the tribunal is a 3. It don't stop you from having different divisions of a tribunal that allows for the similar composition. So you may have as much as 9 members of a tribunal with a construct of 3 each, using the same composition. That would allow for the speed in which disputes are being heard, because you have many members comprising of a single panel of 3 that can hear the volume of cases. So that's an approach that we can also consider, depending on the volume of cases that has to be heard. But again, this is an appeal tribunal. How many such cases going to go to an appeal tribunal?
Chairman, if I may, I don't think it should be dependent upon how many cases will go to the tribunal or not. I think I want to agree with Chair that we need, if students are one of the most important stakeholders in education, then we need a representative to represent the parents, the students, the parents of the students in the form of a PTA rep. I don't see what's the difficulty we're having with that.
We have that. To start with, we don't really have student cases, very many of them, very few, 1 or 2. They're usually relationship and practice of the profession. And when that arises under this construct, then there's the PBCJ and the board, and then the parents can be represented on the PBCJ, because the parents are well represented on the board, and then the members of the 2 members of the board will sit on the PBCJ.
Go ahead. Who's there? Okay,
It's
go ahead,
Campbell
Member
Rodriguez.
Rodriguez.
Yes, just, Madam Chair, ask your permission to not turn on my camera at this time. But this is a conversation we started from the last meeting. And whether or not the cases before the tribunal tend to be related to children, parents and children are the major stakeholder in the education sector, in the teaching sector. Without parents and children, there is no teaching sector. And even if the issues do not affect the child specifically for those incidents, it affects the sector. And as such, I think parents should have a seat at the table on the tribunal.
I agree with Member Rodriguez Campbell, and I still think we shouldn't stay because we may not have many cases or we have not had many instances in the past. That should not be the determining factor. If it's 1 case or 2 cases, it shouldn't matter.
Yes,
Dr. Gordon, I differ though. Yes, it will deal with the professional practice, but the cases that I have seen since I've sat in the chair at the ministry has to do with altercation between teachers and students and teacher pulling gun and different things like that. It's not just, I don't know if you consider that the practice, but those are the kinds of situations, you know, you're shaking your head. Is that you're considering those the practice of teaching, Dr. Gordon?
When a case, in this process, Minister, when a case gets to the tribunal on the professional practice of the teacher, then it is really a matter of the practice of the teacher, which JTA will represent, the judge and a lawyer who would have investigated or would have received the investigation of the case at that point. So at the level of the tribunal, we really need the judge, the lawyer, and the JTA. And as Member Gale suggested, we may have a panel of people from whom we can draw, but when the tribunal sits, it's just 3 persons.
That's because I think, Dr. Gordon, traditionally, that's how it's been traditionally. doesn't necessarily mean that's how it should be going forward. And my understanding of these appeals is that they're generally appeals with regards to some process or the law, right? I'm actually going to ask further, going back several meetings to what Member Braham had brought up, that the appeals tribunal be asked to consider not just the matter of the law, but also the severity of the issue. Because in many, many cases across many boards, decisions are taken when you have issues happening at schools, and the case is appealed on a matter of law, and it is thrown out, and the teacher goes back into their position. Even if they commit an egregious act, you know, if it's felt that there's somebody in a meeting that shouldn't be in a meeting, it's thrown out, and they're back in the same classroom with the same student that they would have wronged. And these are the things that just happen, and we just carry on with them.
The teacher is entitled to protection under the Charter of Rights. We can't overthrow the Charter of Rights. 16.2 requires a fair hearing. And if something was done that was not fair by the employer, then it is just unfair that that unfairness be thrown out. And I stick with the original composition that was proposed, and this idea that fairness, as you may have put it, relying on the law, is not something we want to condone. I am not going there.
No member, let me stop you in your tracks. That is not what I'm saying. I'm saying for the tribunal to not just consider the point of law without considering the substance of the case. We'll be asking the tribunal to consider both, not just one.
Minister, that's like saying throw out the law and just look at the substance. And I really am going to be for the rule of law, and the rule of law to protect persons and their right to use it, consistent with the Charter of Rights. So I want to leave at this point, because I have this other matter that I must deal with, by saying I stand with the original composition. I disagree, if it's a majority position here, with the majority, and I wish that to be noted. And I will be voting against the inclusion of the PTA into these professional matters. So I apologize. If I can come back soon from my other meeting, I'll be happy to come back and join. So I just want to leave with that, and I thank you very much. And Minister, there's a matter I want to talk to you outside about, but I will get your number and give you a call. All right.
Noted, member.
Yeah.
Chair, I appreciate and can understand what your recommendation is seeking to achieve in terms of having the protection of interest in this case. First of all, you have the judge, who I would assume would be, there's no conflict there because the judge represents that level of independence. Then what you're proposing is to have that interest in the parent, who assumably would represent the interests of parents' issues, issues raised by parents or the child. And then we have the teacher. In this case, we have two teachers. One that represents the JTA, or nominated through the JTA, appointed by the minister, and one that is a retired teacher. An option may be to substitute one of the teachers with what you are proposing. That's one option. Another option is to expand the composition to another odd number. Make it 5. But then we'd have to find what that interest group will be to make it 5, with the parent representative being number 4.
A lawyer is absolutely necessary. Absolutely.
Well, the judge is a lawyer.
Yeah.
Not hearing what was just said. Sound has gone.
A lawyer is absolutely necessary on the tribunal. There's a lot of legal work, and the lawyer does that work and advises the judge.
But would this tribunal, in terms of the administrative duties of the tribunal, have in place a secretary? That could possibly be the attorney, an attorney, or have those qualifications of an attorney to provide that administrative role. Because if you're talking about research, the secretary of the tribunal, who can be an attorney, can assist, if that is the skill set you want to cover, but not necessarily to hear the dispute.
It's not just the research, because we do have a lawyer that assists the lawyer on the tribunal, and that lawyer does the research. A lot of research, but then the lawyer takes the findings of the research and spends time on the findings in order to advise on the tribunal, advise the judge. So we can't ask the judge to carry out the same role of the attorney at law.
I would have put 2 options out there. If there are any other member who is inclined to either agree or complement. No, I've put the option in terms of the construct being the judge replace one of the teacher with what the chair is seeking to do in terms of having the parent, or you expand the composition of the construct to 5, which would include now the teacher, and we find another component.
Madam Chair, I would go the route of increasing the numbers to facilitate, but I am in strong support of your suggestion, and I do not believe that there is any reason that should not happen. So if it means we have to increase, unless there's a reason we can't, then I would say we need to increase the number to ensure that a parent rep is on the body.
Through you, Chair. I think I would want to, I guess, go with your second option, not to stick with 4, because then that's an even number. And we don't want really a deadlock. We want to give the opportunity where we have the odd number. So I would possibly want to go with the 5 so that the parent can have a voice. And I think even if it is not a teacher-child situation, it is a school. And so I think a parent could still have a voice in whatever it is, decisions that's being made, because children are being sent to school by parents. And so I don't have a difficulty with a parent, exactly, with 100% of the cases. So I don't necessarily have any issues with the voice of, and I think even when you listen out there, parents, I believe, want to have some sort of a voice at the table as in the decision-making process. And so I would expand it, I guess. 5 is not it's not a large number, and I don't have a difficulty at all.
Chair, I too support that position. If there's a need to expand to 5 to accommodate the Parent Teachers Association rep, then I would say let's increase.
Chair, if I may, in terms of the odd number, there is already a provision that allows for the chairman of the tribunal to have a casting vote where the voting is equal. But in terms of the parent having a voice, I understand the position of members, but as Dr. Gordon was saying, when it reaches to a tribunal, they're really looking to see the process that was undertaken in addressing the matter, looking at the facts, looking at the law to see whether or not the process was followed. And so if it is then that we are going to introduce a parent, then I'm proposing that that parent would have to be of a certain level in order to be involved in a tribunal setting.
You can't discriminate
at all. I don't
and
think
then that might hinge on
There
discrimination.
are lots of parents who are lawyers out there. There are lots of parents who would have, who are professional and would have the qualifications to sit on such a tribunal.
Remember, what you're saying, is that it is not a dispute to be heard in the first instance. This is at the stage of an appeal. It would have gone through all the processes already. The small difficulty that I have with giving, in this instance, a chairman the casting vote may place a little pressure on the chairman. I don't like, in the essence of a tribunal, to allow that, because you may have a situation where at least one member might have a dissenting voice to the issue and might, put forward a minority report. Again, when you have these situations, to place the burden on the chairman, who you would want in the first instance to make an independent decision, to be looking at all the others to give a casting vote. I like independence. And so that's why I'll be more inclined to remove that component of it. If you're going to find out, as Member Cuthbert Flynn had indicated, we can find enough parents who are lawyers and who at a particular level that can sit on this appeals tribunal. And that would, Ms. Gordon, that would help your seeking a lawyer.
Madam Chair, I think we need to be careful, though, about taking that suggestion about a parent being of a certain level. We have to be very careful with that and leave it to the parents to decide who should represent them.
But of course, you would agree that there would have to be certain levels of understandings to determine who sits on a tribunal.
Yes, but we just have to be careful with the wording of what we just said. That's all I'm saying. And also, it doesn't have to be a lawyer.
And I'm not saying that it ought to be a lawyer. That was only one thought that may have, surrounded these deliberations. But I'm sure that the details that is not going to be concluded in these legislations to make those determinations as to who qualifies can be determined afterwards. And I wouldn't want it to be felt that when I say at a certain level, it is prescribed as being loose.
Minister, please. Let us take into consideration that we have increased the number of the number of representatives of parents on the board. And now we have 4 parents on the board. That at this level, the parents' concerns or the parents' voices can be heard. And at the level of the tribunal, where it is a legal, at that stage, it is a legal matter, that we consider the structure of the judge, the organization representing teachers, and a lawyer. It is really a legal affair. We can't really say that the parent sitting on the tribunal should have a certain qualification. We wouldn't be able to say that to the Parent Teachers Association or the National Parent Teachers Association, because any parent has a right to sit where parents are represented. And in the case of the tribunal, by the time the issue goes before the tribunal, it's really a legal matter.
Is a teacher then a legal representative? So are you saying that that person would have to be a lawyer? Is that what you're saying? Okay, so then the person representing the Parent Teachers Association could be similar.
Actually, the persons that the JTA so far have put on their tribunals are persons who are exposed a lot to legal processes, so they understand so far to date.
But is it a requirement, or is that a requirement, Dr. Gordon?
No, it's not a requirement. It's
Okay.
tradition. That's how it's been. And it's not a requirement.
But because something is
A
tradition doesn't mean
tribunal
it has
should
to be continued.
an independent body.
There's no legal...
But like what Member Cuthbert just said, if it is that we expect, or the teachers are expected to bring to the table a certain level of understanding, then I don't think it would be difficult to say to the PTA that whoever will represent on the tribunal must come to the table with a certain level of understanding. I think that would be a given.
The JTA represents a professional body. The JTA is defending its teachers, and therefore, whoever is assigned or appointed to the tribunal is usually a person who is who understands the law. We don't have to tell the JTA to put a lawyer, because the JTA understands that it is there defending its teacher. The JTA is defending a person.
But I'm sure similarly, the PTA could be made to understand that whoever is going there to represent the interests of the students and the parents.
But this disqualifies me from being a member because I'm a parliamentarian. But take away my parliamentary hat. I'm a parent, so I qualify in the room. Would it exclude me now, given the skill sets that I would have acquired as a trade unionist, to sit as a representative, being a parent? I'm not an attorney, and I don't profess to be, but I certainly believe that I could qualify to sit as a member of a tribunal representing the parents.
But what is the purpose of the tribunal? What is the ultimate purpose of a tribunal?
No, in this case is for the purposes of an appeal, hearing the appeal. That's the purpose. To hear, that's the first and primary objective of the tribunal in this case.
But remember, whatever gets to the tribunal, would have gone through a process, the PPCC.
Agreed.
And then now, the tribunal is another level. By the time a teacher has to go to the tribunal, it is really a review of the matter from a legal perspective and for a decision to be taken. So whoever sits on that tribunal should have some legal expertise. Now, what we're saying is whether or not you can tell the parents that whoever you send to sit on this tribunal must have legal expertise.
Dr. Gordon, you weren't in the first instance raising a concern. I don't want to come across that, we're debating this. We're debating this. In the first instance, there was no concern raised with the previous composition until the chair has sought to include the representative of a parent, because that's where the discussion has gone. Now, all we have to do, because I'm still not buying the argument that because it has gone to the stage of an appeal, that it requires an attorney. The judge would qualify in that case. But I remind you that you never came with a concern in relation to the original composition.
Madam Chair? May I, Madam Chair?
No, it's two teachers you're having now.
Madam Chair, are you hearing me?
Yes, go ahead, member.
Right. I just want to support that point just made by Senator Gale, but I think we can also, Madam Chair, put the matter to a vote for the membership, because at the end of the day, the decision that we take here with regard to this matter, whether we go with a parent on the tribunal or not, it's the members of the committee who are going to have to handle any pressure that comes from the wider society about it. And as such, I think we can put the matter to a vote at this point.
So, Member Rodriguez.
I was just about to say the
Rodriguez.
same, Madam Chair. I think we have ventilated the matter enough. I think we should put it to a vote.
Before we go there, I have to say that I've always questioned the composition of the appeals tribunal, right? Because if it's matters of professional conduct of teachers, why wouldn't you have an independent tribunal and not have to hear about making changes, because the status quo that existed has not been serving us well?
Chairman, may I just make one reference, as you say we are debating, to Member Gale. This document with the teacher, we had done that a long time ago when that was how the tribunal operated. Now, since then, we have not really had a discussion on the composition of the tribunal. But out of experience, we changed it. And so we would want to have we don't need to have the retired teacher, because the JTA represents the profession, and that's good enough. So we don't need to have a retired teacher, but we know that a lawyer is needed. No judge that we get, is going to have the kind of legal time to put into the cases without support of a lawyer on the tribunal, which excludes the agency. Because if the agency staff gets into that, then we get into a lot of trouble.
Okay.
But the lawyer is on the tribunal, is a member of the tribunal, and the tribunal is allowed to have a paralegal or have a young lawyer to help them with the research. But a lawyer, an attorney at law, needs to be on the tribunal. And we have been doing that for the last 10 years, and it has worked well. We have no backlog of cases.
The results that come out, though, Dr. Gordon, you know it, it's going to shake my head. Let me ask this, though. If these are cases brought by teachers to a tribunal, and the teachers are represented by the Jamaica Teachers Association, how can you have a member of the Jamaica Teachers Association sitting on the tribunal? It doesn't make sense.
That's an agreed position long ago
Huh?
with government.
Yeah, but it
Minister.
just does not make sense. You have a tribunal. The JTA is bringing the case on behalf of the teacher, and on that tribunal, you have a member sitting from the JTA. That just seems like a conflict of interest in the tribunal. I know it's the way it's been, but we're examining things now.
Actually, Minister, as you know, the JTA, the person who represents the JTA on the tribunal is usually a retired, the person they nominate is usually a retired JTA officer. The person who represents the teacher is an active JTA member who represents the teacher. So far as I am aware, it's a long time negotiation in the setting up of the tribunal.
So you have two JTA representatives, you have a judge. We need to have somebody else who's independent on this. But
So
no.
Member Cuthberg, the way it is now, you
Yeah.
have a retired judge, you have a lawyer, right, Dr. Gordon? A retired judge, a lawyer. No? As it is now, in practice now, a retired judge, a lawyer, and a representative of the JTA on the tribunal. But coming in front of the tribunal to prosecute the case is a JTA rep who's representing the teacher, who's bringing the appeal. That does not make sense, yeah.
Not all cases are represented by JTA, Minister. There are other cases that are not represented by JTA.
Chair, I think we, as members of Member Crawford has said, we have ventilated the issue, and I think most members are going for the addition of a parent, which would make it four, because currently it's 3. So I am thinking to add the proposal to add the parent, as most members are saying, and an attorney at law. Currently, there is no quorum under the schedule. So we could specify that the quorum must be 3, and one of whom shall be the attorney at law.
it, you'd have to determine the quorum.
Right.
All right, so are we saying 2 attorneys, a judge, a JTA rep, and a parent? Is that what
No.
you're suggesting?
Chair,
No.
I want to ask a question
No,
because the
attorney.
more I look at this, so let's deal with the C, the representative nominated by the association, approved by the minister, who shall be a registered teacher of at least 10 years of service in the profession. Is that a practicing teacher? Could that still be a practicing teacher?
What I'm saying, member, this composition was decided on by people long ago. We have it in front of us now. We need to make a different decision because it does not appear to me that you have a member of the JTA representing teachers, bringing a case to a tribunal, and you have a representative from the JTA on that tribunal.
The question I was asking with C is whether or not the person is practicing. It don't have to be practicing, but how it is constructed here might be inescapable, that they nominate someone who is practicing, which may cause a conflict of interest. Because under normal circumstances, you don't have someone who, at the level of an appeal, that's supposed to promote independence, to be someone who is entrenched in the system. I just want to remove that burden of doubt that might be created. And this does not specifically suggest the exclusion of someone who may be practicing.
A registered teacher is not a practicing teacher. A licensed teacher is a practicing teacher. A registered teacher is just somebody registered in the profession with the necessary qualification.
But this person,
So the
can always be called back to be utilized.
if the person satisfies the requirements for a license to practice. But in this
Madam
case, the
Chair,
person is not
The
practicing.
argument
Is it
doesn't
possible?
hold up. Hold on a second, member. The argument does not hold up that the tribunal is looking at matters of law, and so you need lawyers. You know, that argument doesn't hold up here if you have this representative. Go ahead, member.
I support you on that, which is why I was concerned about hearing of lawyer. But in addition, Madam Chair, a middle ground could be, even though they themselves were once teachers, maybe use a principal. Because we know that within the system, quite often principals do have a wide perspective on what is happening. And they're from the management of the school, which means they're not necessarily in the classroom. So I don't know if that's a consideration.
Member
we could
Rodriguez,
make.
do we need an independent tribunal or not?
I would go the route of an independent tribunal, Madam Chair. But that's me. I would go the route of an independent. But if we're not, because of the fact that it is said that the tribunal should, just as it should be a jury of your peers, that concept, I'm just thinking out loud, Madam Chair, that maybe we could go the route of a principal. Not hearing anything if anyone is speaking.
Senator Campbell Rodriguez, you're not hearing anything because we're working the mind around this one still.
You know, sir. Okay. Noted.
Remember, Brian, I want to take a lawyer and put it. Miss Sherland, you can help us. Chair, sometimes, so we have something entrenched, and we are doing a review. And a review oftentimes prescribes changes. And so sometimes a policy direction can dictate the legislation. So let's pull back a little and see what is the policy direction that we are trying to pursue. And maybe that policy direction can guide us in terms of the end result. And what I'm hearing in terms of a policy direction may very well seek to propose the inclusion of a representative from the parent. That's a policy direction. And maybe if we examine that and refine it, we can come up with the most applicable solution if the policy direction is going to guide us. And I want to suggest that we consider that approach. Let the policy dictate. And since we are doing the review can always condense in our mind the changes that can be dictated.
Chair, good afternoon. This is Nadine Wilkins.
Please go ahead, Ms. Wilkins.
I was looking at at what was being said, or listening to what is being said. And there is some merit to your point, Chair, about the representation from the professional association being a voting member of the appeals tribunal. Perhaps they should be entitled to watch the proceedings, but not necessarily be so integrally involved in how the decision is arrived at, having regard to, as was pointed out, the individual quite often is of that association. The individual who is the subject of the matter is quite obvious, often from that association. So maybe they should at least, though, be permitted to watch the proceedings or have a representative who like, I don't know, somebody from the organization or somebody they would want to represent them, to watch the proceedings. Forgive me for being a lawyer, but the reason it was felt that an attorney being a member would assist is that even notwithstanding the chairman being a retired judge, quite often the attention to detail in analyzing a particular provision, whether it is in bylaws, in rules, in regulations, in a statute, quite often it's an attorney on a panel who brings that and who provides the in-depth analysis that assists in the discussion of a particular matter. So, forgive me for being a lawyer, but there is, quite honestly, a role for an attorney over and above the chairman being a judge. And there are a number of tribunals that have attorneys on them for that reason. So many times the matter turns on an understanding of how a provision is to be construed. The suggestion about a parent, I don't think just a parent without more would satisfy the requirements one would want of an appeal tribunal. I think just a parent, any parent, I don't know, I'm not sure. I think it is a good thing for a parent to be involved in how some of these matters are decided, but the technical nature of some of these matters that are considered by these tribunals, I'm not sure just designating a parent would be helpful.
All right,
Thanks,
you,
Chair.
thank you so much, Ms. Wilkins, for that. I agree with you with regards to having an attorney on the board, a judge and an attorney. The parent, again, I'm going to insist a parent beyond. We can say what the qualifications should be. And that I totally agree with you as well that a representative of the association can watch the proceedings, but to be on as a member of the tribunal, it just speaks to a conflict of interest. Because the case is generally brought by whether it is an attorney that is paid for by the JTA or the JTA's own attorney about a teacher to the tribunal. I see some concerns. Please air them.
I'm just indicating, Chair, that a teacher currently sits on the tribunal and the matter of bias. I'm not aware that that has been an issue.
No, I understand that. I
years.
understand how it has been for decades. It doesn't mean that's how it should be going forward.
But the
We're trying to change. We're trying to change things. We're trying to create a new environment through this bill. We're examining everything. Just because it's been that way doesn't mean that's how it should be going forward.
But Chair, though,
Chair.
you're expected as a member to be objective, as a member of a tribunal, to be objective. And so if we're taking issue with a teacher who is also being tried, then taking on a parent, I don't think it would be fair to the teacher, because you have a parent, but you are not going to have a representative of that category that is being tried. So if we are including the parent, the teacher should also have a voice for a peer then. That's just my opinion.
But doesn't the teacher already have a voice?
You have a retired teacher. No. No? You don't have a retired teacher now. Oh, so this is just proposing the retired teacher.
in the early years, the retired teacher was actually the chairman of the board, of the tribunal. That's where the retired teacher was. And having removed the retired teacher from that position, we were satisfied with the JTA representing the teacher.
Madam Chair, I'm getting a bit confused now. What are the positions that we are saying we currently have? What are those, Madam Chair? Because I thought a teacher was there.
Go ahead, Dr. Gordon.
The position now, there's a retired judge who's a chairman. The Jamaica Teachers Association has a nominee on the tribunal, and there is an attorney at law, who is a nominee of the Minister of Education.
Just to clarify, I didn't mean to interject, but is member asking for the composition in the bill or that currently obtains with the tribunal? In the bill.
In the bill.
Okay.
Yes.
And we could share both.
As you know, the bill is being drafted, and we have made changes as we go along. It is
right. So I want to know, what is it now in the bill that you're proposing to us?
What is in the bill now, and has been in there from about 2010 or 2011, before we made any changes to the tribunal, is that a retired teacher, a judge, and an attorney at law would form the tribunal. Isn't that what is it again? Sorry.
Just to clarify, so in looking at the current constitution, it's the chairman of the tribunal who shall be a retired judge of a superior court of record, a retired teacher, and the representative of teachers' associations recognized by the minister and nominated by the association in a manner approved by the minister, who shall be a registered teacher of at least 10 years of service to the teaching profession. So that's the current.
So right now,
and the reason why we did that.
Right now you have three. Hold on, Ms. Gordon, just a minute, please. So you have three: the retired judge, the JTA rep, and the retired teacher. And if we add the parent,
but that's what's in the bill. But
right, I'm just trying to understand, Minister. If we add the parents, we're at 4, and we prefer odd numbers. Because I think all members of the committee, and it is what the membership of the committee will make the decision, and everyone I've heard so far, the only person I've heard give an opinion on it is Member Miller. And everybody is in support of the parent, so we can almost say the parent is to be there. So that's 4. So what we really should be debating now is, what's the 5th person? And I agree with Minister that there seems to be a conflict with the JTA rep. There seems to be, but we can come back to that. It's how do we fill that 5th spot so we don't have a gridlock with an even number? Because I don't think there is any member who is going to be against the parents, so we know it's 4. And we have a retired teacher and we have a JTA rep. So we don't need to argue anymore on any more teachers. I don't think, unless I'm missing something.
But remember, the issue is, this is a tribunal that hears matters brought to it by teachers. And those teachers are represented by the Jamaica Teachers Association. It does not make sense to me that you have a representative on the tribunal that is of the JTA.
And Madam Chair, that's why I'm saying if we take that position out, Madam Chair, and let it be a principal who is not on the executive of the JTA.
We have to also understand, though, that most teachers,
including myself,
are part of the Jamaica Teachers Association. As I was indicating before my proposal, add the parent, add an attorney at law, and that will be 5. And also to know that that one person is not the majority. And in doing the vote, we have to have a majority vote. So that one person is not a majority. So we have to also consider that aspect in having an issue with the whole matter of prejudice or bias. And as I said before, there's currently no quorum under the bill. And so if we put a quorum of 3 and we ensure that a legal person is present, so I'm not sure if it would be time to say one of whom shall be the attorney at law, then I think we should be able to solve the issue. So it's something to consider.
Members, I'm not totally satisfied. I want to ask, despite me not wanting to come back here for another meeting, I really want to hear from Member Braham on this, and I haven't been able to get him.
So, Chair, what is it that we'd want Member Braham to consider, him being an attorney?
No. He.
What would it be that Member Braham would be considering? If we could just... Oh, okay. Oh.
Madam Chair, Madam Chair, in the interest of moving ahead,
Yes.
We should consider the proposal of Mrs. Gordon-Jones that we have a tribunal of 5, the retired judge, the representative of the nominee of the Jamaica Teachers Association, which is usually a retired person anyway, from the association, a parent, and an attorney at law. And a retired teacher. That's 5. Usually they are retired from the organization. Yes, usually the person from the JTA, has always been a retired member of the JTA.
But members, my question or my concern still about the issues being brought to the appeal tribunal are of a certain nature, a particular nature, and they're represented by an association that is represented on the tribunal. There's something not right with that.
Chairman, please, professions investigate their members themselves, their practice. If you look at all the other professions, the professional is the word is not tried, but when there's an issue, the professional issue is discussed by the professionals in that profession. It goes for doctors, lawyers, nurses, because they want to be responsible for their practice. And so what you're seeing here is not unusual for professions, because they are the ones who know the practice and therefore can say to their colleagues that there's malpractice, what you have done is wrong, because they have the experience to do that. And
Chair, if I may, In terms of the parent, just for the committee to consider these words in considering the person, it could read a nominee of a body appearing to the minister to be representative of the interest of parents. So that is something similar to the wording on the board of the council. So that would be the possible wording for the parent as the member on the tribunal. So it would be a nominee of a body appearing to the minister to be representative of the interests of parents.
I'm not there yet, honestly. I'm still on the point. Coming to you, member. I'm still on the point about the JTA being on the tribunal. Because if you look at how things happen, they happen at the school level, they go to a board at the school. Right, the board makes a decision. The decision is then appealed to the tribunal. So it's not all the way you're dealing with the profession, Dr. Gordon, as in the nurses or in the doctors or the lawyers. I stand to be corrected, right? If something happens, you're going, Member Green, go ahead.
Chair, again, let me just apologize to the committee. I did indicate that I had a function, and apologies for those who I know are watching camera this time. I did formulate, Chair, so apologies if I missed some of the conversation. And if the point that I am going to raise has been raised already, right? Clearly, where I'm coming, I see us deliberating about the membership of the tribunal. Just in terms of my viewpoint, Chair, the critical element comes down to the numbers. So, if there is a representative from the JTA, for example, I don't think that in and of itself would present a difficulty for the tribunal to justly and judiciously adjudicate on matters that are brought before the tribunal. So what you definitely want is to have a variety.
Member Green, the matters are generally brought by JTA.
Yeah, so what you want to ensure, Chair, is one, that the person that the JTA is not in the majority, right? As my understanding, they would only have one member on the tribunal, right? That you would have other members. So again, my understanding, you're going to have a parent rep, you're going to have an attorney at law, you're going to have other people of that nature. So ultimately, even in relation to the sort of influence that the JTA could have on the outcome, it would only be in relation to their one member. If the majority determines that the appeal should not be allowed, for example, then I think you would have enough safeguards there. Again, I think I appreciate that there is a little difference in this than in other professional organizations where you have a body that advocates on behalf of, for example, teachers in this regard. And I share what the difficulty that you are wary of. But I do believe that once it is that the JT has a majority position, that you do have different perspectives, but you do have a representative who would, and again, it doesn't mean if the person is a part of the association that they would share the view of the association in relation to a matter that is brought on appeal. Again, it is not unusual for persons in the same profession to adjudicate on the standards of that profession. I do believe, as I've said before, the teaching profession is a little different because you have to look at the interests of multiple stakeholders and you're dealing with the most vulnerable in relation to our children. But if the representative of the JTA is only 1 out of 5, I think that might be sufficient representation and also guard against your fair share that the decisions may be skewed in a particular direction. So I wouldn't have a challenge with the JTA having 1 representative on the tribe.
Chair, if you take the construct of the Industrial Disputes Tribunal, the chairman is a nominee from the Minister of Labour. The employer rep is a nominee from the Jamaica Employers Federation, not necessarily a practicing employer, but maybe a retired employer. The worker rep is nominated from the trade union, not necessarily a practicing trade unionist, but may have been a former trade unionist, but the person is retired and no longer practicing. And so you have both sides having their nominated representative. In this case, I assume that the JTA, having the retired registered teacher, is not a practicing teacher as we have determined here, but would be someone nominated by the JTA. So I'm not seeing the challenge. Where I think we ought to now take it is what we're seeking to satisfy in the first instance by having the parent, that would make it number 4, and the attorney, that would make it number 5, and we can have a compromised agreement.
Chair, if I may, in relation to the JTA rep though, currently it says who shall be a registered teacher. So if it is that we don't want the person to be practicing, then we would have to specify, because a registered teacher can also be licensed and can also be practicing as well.
I would have asked that question earlier about the practicing and the registered. So that would be the disqualification, possibly. If they're not practicing.
No, you mean if they're practicing?
No, if they're not, we don't want them to be practicing.
Right, okay.
Also, just to note, Chair, again, so does not assume that once you sit at a tribunal, will not necessarily and ought not to, as a position in relation to conflict of interest, have a very direct relation, and there are more forensic words in relation to the matter that is brought before the tribunal. So, again, there are also additional safeguards. If a matter comes up, for example, from a school that person is involved in, that clearly will arise a conflict of interest. Just as, again, if you're brought before legal counsel and you're from a firm where the person who is on the tribunal or the disciplinary committee practices at that firm, then that person would have to accuse themselves of the matter. So just to say that there are also additional safeguards in the law to guard against bias.
Member Green, I'm going to make a distinction between the case being heard and then you have the appeal. We're looking at the appeal tribunal.
Yeah, understood, Chair. So the case, let us say the case having been heard, the council did not find in favor of the teacher. In other words, the council found that in this instance, the teacher did not live up to standards and would have made an order in whatever regard. And now the case is being appealed. I do appreciate that. I get the point that in practice, it is usual for the JTA in that instance to almost act as lobby representative for that teacher in making the appeal to the tribunal. But again, the point that I made, Chair, I believe that one, the chairman of the tribunal should not come from the JTA, and I think it's there. And two, the JTA should not have the majority of the members. And that three, again, if there is a matter that the person has a direct relationship to that matter, then the person ought to properly recuse themselves. But other than that, again, if I do not think, not because the JTA brings the matter, means that the person who was appointed by the JTA will not be able to objectively analyze. And I think the point that member gave me is reasonable. In other words, you have workers rep, you have employees rep, but it doesn't mean that they're always on the side of the employer or they're always on the side of the worker based on the case that comes before. What you're trying to do is to constitute a tribunal that has a certain level of balance so that there are varying perspectives, but you put safeguards in relation to maybe the chair, things of that nature. So I think your discomfort is valid, Chair, but I also believe that based on the composition that we have before us, it would not necessarily open itself for bias if the matter, the teacher, is now represented on appeal by the judge.
Okay. We will move forward with 5 members on the tribunal. The chairman of the tribunal to be a retired judge of a superior court of record. Number 2 member, a retired teacher. Number 3, a representative of, however the wording is, an association that represents parents. Number 4, an attorney. And number 5, a representative of JTA. Go ahead. No, I said parent already. I said parent already. Well, go ahead, Ms. Gordon-Jones.
What was the chair? For teachers. Right, so 5 would be it. I think chair is just adding the others, the 2, which would be the attorney at law, and we would specify the years of that person. That's the proposal. And the last one would be a nominee of a body appearing to the minister to be the representative of interests of parents.
Okay, could you read it through for the record?
So the attorney at law, the proposal is for at least 10 years of experience. I am not sure if the committee is minded for the 10 years or lesser. Very well. So it would be an attorney at law of at least 10 years experience, and the 5th person would be a nominee of a body appearing to the minister to be representative of the interest of parents.
Sorry, Minister, I've been translated, but just a question. Do we stipulate, I'm not looking at the provision right now, do we stipulate who the chair, that the chair should be appointed by the minister. What is the stipulation related to the chairperson?
If I may, the paragraph 2 states that the chairman of the tribunal and other members of the tribunal shall be appointed by the minister and shall hold office for such period not exceeding 2 years as the minister shall determine and shall be eligible for reappointment.
Okay, thank you.
Or could we take the items, the carryover items? Please go ahead, SG. Yeah, Ms. Shortland, you want to do the carryover items?
Minister, I think the next matter is to go to the redrafting of the clauses 51 to 64 and also the amendments to the first and second schedules.
So members, was this emailed? Okay, you should have an updated part, part 8, a redrafted part 8, part 7. Or 7, which one is on? Investigation, disciplinary inquiry and action that I don't believe we'll be able to take today. But also, just to complete on the other clauses, we were supposed to look at the comments, the submission from the homeschoolers. I went through it, and for the most part, every single person was saying homeschoolers should be exempt from this bill. Yeah, they shouldn't be mentioned. Yeah. What I'd like to do is to invite a technical person from the Ministry of Education and Youth to the next meeting just to explain how the ministry deals with homeschoolers currently, because they do have to be registered, right? They have to indicate to the ministry that they'll be homeschooling their child, and right there is some procedure. I know the members of the Homeschooling Association had called for a policy to be written, and it was something that I committed to. We haven't begun that process yet, though. And so before we deliberate on that, whether or not they should be included or excluded, I think we should hear from the technical persons at the Ministry of Education and Youth as to what exists currently.
Madam Chair, maybe we would like to keep in mind that the bill is about the practice of a teacher. Wherever the teacher practices, then that has implications for the profession. It doesn't matter if it is in a public school, a private school, or home school. Once the person is practicing as a teacher, then that person is governed by the profession, which is what the bill is about, the practice of the teacher. So the teacher might be practicing with a group of parents, but it's still a practice. It's not a program.
So what you're saying is that once a teacher is involved, irregardless of the geographical location, the teacher should be under the scope of this legislation. Well, that's the only distinction now, whether or not the student being homeschooled is being homeschooled by a parent and not necessarily a teacher. Not a registered or practicing teacher. So I'm a parent, and I decide to homeschool my child under my tutelage. Then I'm not under the scope of this.
No.
But if I now ask for the assistance of a registered or practicing teacher, that teacher should be under the scope of this.
Yes.
Right.
Thank you.
So, Chair, are they asking then to not be registered or practicing teacher then? The homeschool?
To be exempt, totally exempt from this bill.
No.
I'm asking if the use of a teacher in this case must be the use of a registered teacher or a licensed teacher to assist with the homeschooling.
Or are they just going to be parents? So they're just going to be parents. They're not going to be registered or licensed at all.
Now, if the parent is promoting the use of a homeschooling mechanism and they want the assistance of a teacher, then that teacher should be a licensed or registered teacher.
And then they would have to be a part of this bill.
Yes. They would be under the scope of the bill.
On the scope of the
bill. Go ahead, Member Miller.
Thank you, Madam Chair. If my memory serves me well, I think when they made their presentation for the homeschool, they were referring to the parents being the teachers of the students within their care in terms of their own children. I am of a different dispensation where that is concerned, because I believe that if, you know, yes, homeschool is there, but
We're not hearing you, Member Miller.
Each should be the persons, and that will be my position.
We must have a lot of your position a while ago. You broke up.
I'm saying I think my recollection of what their presentation is that whenever the homeschool system, that the parents will be the teacher of those students. I'm of a different dispensation where that is concerned, as I'm of the belief that a trained teacher, I'm not against homeschooling, but I'm of the belief that a trained teacher should be teaching those children and someone who is registered as well. So that will be my take on the matter and my stand on the matter. Thanks.
So members, unfortunately, I have to leave. So I'm going to ask you to just read through the comments again from the whole school, the homeschooling persons. The matrix, there's a little matrix. It's called part 2.
We'd have to go back in the record to see what was discussed, because I think the discussion was if you teach your own child, it does not apply, but if you are going to teach other children, then it will apply. Right, so I think that was the discussion.
Yeah.
Right.
All right, so we will do that at the next meeting, and the revised clauses for part 8. Part 8. The next meeting, even though I'd hoped for this to have been the last meeting, but the next meeting will be February 23rd at, I'm sorry, I packed away my things already, at 10 a.m. February 23rd at 10 a.m. 23rd at 10 a.m. All right. Oh. So members, we're hoping that that would be the last meeting.
Madam Chair, did you say February 21st? Was it 21st?
23rd.
Or 23rd, okay, thank you.
At 10 a.m. All right. Thank you so much, members. Thank you. We aim.
Welcome to PBCJ Presents, our weekly current affairs discussion series. With us in studio, we welcome Mrs. Deborah Chen. Our topic is Do Your Part, Check Your Heart.
What we would like to see is an increase of the number of persons coming for screening, just coming and saying, I want my heart to be checked. Programs like yours are fantastic and it really encourages people to come. So we're hoping that more people will turn up. And from that, if we do find any problems, then we can take the necessary steps to prevent it ending in a heart attack or a stroke.